originalist, I usually hate these kind of questions when someone said, how would a person who's deceased feel about something now? But let's do it anyway, despite my lack of taste for that. Would he agree with this delay thing that the Republicans who adore him in the Senate say is what they're going to do with any nomination advanced by the president?
That's a great question. I don't know that I have a clear sense, because I think if the question were, what does the Constitution mean? I doubt he would see a hidden clause in the Constitution that says the Senate shall give advice and consent except in the last year of a president's administration, or the president shall nominate except in the last year of his administration. And of course, the precedent is pretty strong. With Justice Kennedy in 1988 getting 97 votes out of the Senate. The other three weren't there because they were running for president.
Nominated by Republican President Ronald Reagan and confirmed by Democratic Senate.
Yeah, but the reality, of course, is that the whole process with the president and the nominations has become so incredibly politicized. So, as much as I think the president should have the right to nominate and the Senate should consider it, I don't think that if it were the other way around, the Democrats would be behaving much differently. I think this has just become the norm, and somehow some adult has to stand on the stage and say enough of this game.
Who would that be?
I don't know who that is right now, because we've become so polarized.
How about his perspective on delay as an originalist?
I'm not sure that really plays into it at all. And I do want to take issue, though, with the Justice Kennedy allusion, because Justice Kennedy, you'll have to recall, was nominated to replace, in 87, to replace Bork, who had been borked even earlier in the year. So that was open much longer than we're talking about this opening.
But are you troubled, as people who've spent a piece of their life not only in the law, but in the highest reaches in the law, are you troubled by the notion that the American people will have a court for at least 350, maybe 400 days without a full complement and a ton of 4-4 decisions on issues, whether it's abortion or affirmative action or public sector unions, that probably won't get resolved? Does that trouble you?
It's not ideal, but it doesn't trouble me so much for this reason. The court has a discretionary docket. It doesn't take every important case that comes before it. It says no to lots of important issues. And it can always come back next year to decide cases that may have been split 4-4 this year.
You with him on this?
No, I'm not. I don't see the principal justification for the delay. I see the power justification.
The Democrats should do the same thing.
Well, and I wouldn't say they're justified either. I'm saying we ought to get above, have to find a way to rise above this partisan warfare and begin to execute the government the way the government's supposed to be executed. And the problem is it's not just the court, it's not just the justice of the Supreme Court. We have this whole nomination process that has slowed to almost halt, and we have important offices in the government need to be filled. This was not the intent. The original justices are appointed within days, within weeks, certainly not within months. And the idea that we should be leveraging this opportunity in the way it's being leveraged, I think is just inappropriate.
For a lot of us who weren't good enough in law school to get the clerkships that you got, namely me, a lot of us believe there should be lifetime tenure. Justice Breyer was with me a couple of months ago, and I asked him the question about a limit on tenure. Here's what he had to say.
There should be a long tenure. Whether it's a term of years or not, maybe it would be better to have a term of years, but it must be long, because you don't want a person in that job thinking about his next job.
What do you think about that? Wouldn't that, some people are talking about 18-year terms, a couple of them would expire. We have a situation now, you guys know this as well as anybody. Ruth Bader Ginsburg, liberal, 82 years old. Anthony Kennedy, often swing vote, 79 years old. Steve Breyer, who was just here, 77 years old. The seismic shift in this court, not only Scalia's seat, but arguably their three in the next, could change this court for 10 presidencies potential.
Yeah, that's very true, and often you'll see the justices resign. It's unfortunate, of course, that Justice Scalia passed away before he felt that he was in a place where he wanted to resign.
Well, a lot of people thought Ginsburg was going to do that. What do you think about lifetime tenure? Limited tenure.
I think it's a great idea. The German system has 18 years, and 67 years is the maximum age you can be as justice. That would be 4 of those members that would have to step aside. I think Justice Breyer raises an important point, though. You don't want them to think about their next job. We could solve that by saying, look, you have 10 years guaranteed, and after that we could think of it as a Supreme Court vote them off the stage lottery, where you just pull the names out of the hat to see who we have to get off. And if we did that and we had more regular turnover, the political cost of any particular justice wouldn't be as high. And in other constitutional democracies, you see justices being appointed and stepping aside, and it's not such a big issue every time it happens.
But the problem is the stakes are so high, and that is a difference between today's court and the court in the past. You have so many very important issues being decided by this court, the social issues that you mentioned, that many of the justices feel that unless there's a president in office who shares their views, they're not in a position to resign because the results, from their point of view, could be catastrophic. If the court had less power to shape the national social scene, then this might not be as big an issue.
Yeah, and less power could also mean an easier way to amend the Constitution. I mean, one of the things Justice Scalia commented on is, his effort to restrain judges was weakened by the fact that it's really hard to amend the Constitution. So if the judges get it wrong with a statute, it's easy to fix that. But with the Constitution, we have basically no way to amend the Constitution now. And if it were easier to amend the Constitution, then the stakes in any particular appointee or any particular decision would be lower.
Kevin Martin, it's a pleasure to meet you. Thanks so much for your time, Larry Lessig. Good to see you again. Thank you, gentlemen.